Good evening, ladies and gentlemen. Welcome to the webinar, our retention of patient records and treating close family members. My name is Dr. Hlombe Makhuluma. I'm the medical legal advisor for EthiQal. Welcome. It's always nice to have these kinds of webinars. Just for the first thing that I just want to address, this webinar is accredited for 2 ethics points, and the ethics points will be uploaded to the HPCSA website, or we send it to the HPCSA actually. And HPCSA is the one that really will determine how they upload into your profile. So the important part here is that ensure that in your registration, you've given us the correct, your HPCSA registration number. That becomes very important so that your profile can be uploaded. We are not really sure exactly how HPCSA would do that, but they know that in sessions like these, we just send all the information to them and they upload it. On registration, we received several questions as was requested. And those questions, most of them, will be addressed during the presentations by our presenters. They will address most of those questions, those that would not have been addressed during the presentation. We will have a Q&A session at the end. But during the course of the presentation itself, there is at the bottom of your screens, there is a Q&A tab that you can actually write the questions as we continue to present. We will address those questions at the end. There were a few questions that were not really relevant to the topics of today, and those questions will be addressed directly to the practitioners that have really asked those questions. We also, at the end of this presentation, we will have a short survey. Please just complete the survey. It's going to help us to understand where areas where we can improve, things that you need as the attendees of these sessions. Just to talk about EthiQal first, EthiQal provides professional indemnity cover. And the real focus for EthiQal is on the medical professionals. That is the people called doctors and medical doctors, both the generalists and the specialists. We've been in the market now for 7 years, and it's been great. One thing that is important is that we are homegrown. We're a purely South African company. We've been in the market for 7 years, as I said. We are all South African trained, South African we live here, all of us. And we've got a backup of, there's a clinical team that has got doctors, pharmacists, and nurses. We've got the legal team that has got lawyers and the support staff and other people within that team. Our administration team is also South African. It's also in-house. We've got our sales team that goes out to talk to doctors that you can always contact if you want an advice, both internal and brokers. Brokers are our external partners, but we are all based here. So we are very proud to be EthiQal, and we're very proud that you would attend and listen to a presentation that we give. Just talking about the presentations themselves, the presentations that are going to be given, please, this is an educational presentations. They are not legal advice. You cannot just say that, no, I heard it from there, therefore it's a legal advice. CPDs by definition, it's for knowledge sharing, it's for education. So if any one of you has specific questions that are relevant to them, that specifically need legal advice, they can contact us directly, then we will address those questions directly with them. Without wasting a lot of our time, I will then move on to the first presentation. The first presentation will be by Jessica Falun and Thandi Molaba. They are both, as you can see, legal advisors, and they are both admitted attorneys in South Africa. Over to you, Jessica and Thandi.
Thank you very much, Dr. Klembe. As mentioned, my name is Thandi Molaba. I'm one of the admitted attorneys and legal advisors here at EthiQal. My colleague Jessica Viljoen and I will be discussing the importance of retaining your patient's records, as well as the applicable HPCSA ethical regulations there too. Now, it is no secret that running a private practice comes with many administrative duties and responsibilities for practitioners. The safekeeping of your patient's clinical records should always be prioritized as part of good standard practice and for many other reasons. The retention of patient records is vital for maintaining continuity of care, for protecting patients' rights, for providing evidence of a good standard of care given, and for facilitating ongoing medical treatment, amongst other reasons. Now, medical practitioners have both an ethical and a legal obligation to safeguard patients' records, even after their passing. These records can be available for future healthcare providers, for legal purposes, for research, and for addressing potential medical negligence claim. Now, to discuss more in details about the specific timeframes applicable for retaining records, as well as the relevant ethical regulations, I will now hand over to my colleague, Jessica Viljoen. Thank you.
Thank you, Thandi, and thank you everyone for joining us this evening. I'm Jessica, I'm one of the legal advisors in the ethical claims team, and I hope that we can provide you with some useful information this evening. So just as a general starting point, before moving on to the more specific scenarios that we wanted to cover this evening, we wish to highlight certain important rules, and of course, there are always exceptions to the rule, regarding the general retention of patient records. So in South Africa, patient records are required to be retained for a minimum of 6 years from the time when they became dormant. In practice, this is usually considered to be taken from the date of the last contact between a practitioner and the patient, or the date of the last clinical entry in the records. The exception to the 6-year minimum period, there are a few, and some of the most important ones regard the records of minors, and consequently this obviously also includes obstetric records, and these need to be retained for 21 years until the minor's 21st birthday. Clinical records of mentally ill or incapacitated patients must be retained for the duration of that patient's lifetime. In terms of the Occupational Health and Safety Act, so if you're doing treatment for COIDA claims, WCC claims, and the treatment that you provide falls under the purview of this act, this Occupational Health and Safety Act, this requires you to keep those specific health records for a period of 20 years after treatment. And then where any other statute or law prescribes a period specifically for which patient records must be kept, a practitioner should ensure compliance with any such statutory obligations. So the focus of the rest of our presentation is with regard to the retention of patient records in line with the ethical rules around when a medical practitioner passes away, when a practitioner retires, and when a practitioner closes or sells their practice. So the retention of patient records in the event of a practitioner's death, one can refer to Ethics Booklet 9. And in accordance with this, when a healthcare practitioner in private practice passes away, whether they practiced in a single practice or a partnership, their patient records are included in his or her estate, and they will be administered by the executor or the executrix of the estate. If the practice of a lay practitioner is taken over by another healthcare practitioner, then the executor should carry over the records to the new healthcare practitioner, and the duty then falls to the new healthcare practitioner to take all reasonable steps to inform all patients of the practice's change of ownership, and that the patient has a choice to either remain with the new healthcare practitioner or to request that their records be transferred to another practitioner of their own choice. If the practice of a lay practitioner is not taken over by another practitioner, then this duty of the executor of the estate falls into place, and it's their responsibility to inform all patients in writing of a practitioner's passing and to transfer their records to other healthcare practitioners which may be designated or as requested by individual patients. Any remaining patient files are then required to be kept in safekeeping by the executor for a period of at least 12 months. And the executor during this period has full authority to further deal with the files as he or she may deem appropriate, provided that at all times the provisions around the rules on professional and patient confidentiality are observed. Some practice partnership agreements may include specific provisions for the management of a deceased partner's share in the partnership upon death. And then such management would also include how they would deal with patient records. With regard to the practical implementation and some of the shortcomings of these regulations is that they dictate a seemingly straightforward process for what should happen with patient records when a practitioner passes away. However, many real-life factors haven't been accounted for in the provisions. This could include unexpected or sudden death of a practitioner. They haven't referenced the time it takes for the master of the High Court to issue letters of executorship, and that in practice, it's a very slow administrative process that's involved in the winding up of a deceased estate. So if you take the following scenario by way of example of what can potentially happen, a practitioner in a single practice passes away unexpectedly. All her patient records are kept at her practice rooms, which she rented from a well-known hospital group. But not more than 2 weeks after her sudden passing, the hospital wants to put the practice rooms up for rent. And so the hospital notifies the spouse of the late practitioner that the patient records need to be removed from the premises as they can no longer be stored there. So although according to the EthiQal guidelines, the patient records belong to the estate of the late practitioner and fall into the custody of the executor, here an executor has not yet been appointed. So there's ostensibly no one who holds the immediate authority to manage the records in accordance with these provisions of the EthiQal guidelines. Whilst awaiting the appointment of the executor and the issuing of letters of executorship, we ask who then holds the right to access and transfer those patient records or to take the records into safekeeping as an interim measure. What if the late practitioner was an obstetrician and many of her patients are imminently going to give birth, and those patients need to make urgent arrangements to find a new treating obstetrician, but their care will be compromised if the new practitioner is unable to access their patient records because those records are locked away or there's no one with the official authority to manage requests for the records until such time as the letters of executorship have been issued. And then what about the instance where the executor of the estate is the spouse of the late practitioner and they don't have the means to facilitate the storage of all these patient files? So all these questions can arise in practice, and the EthiQal guidelines don't really provide clear answers to each of these instances. So our advice would then be, in a circumstance like that, that the practice manager or secretary worked for the late practitioner is best placed to commence the administration required in order to communicate with patients and to advise them of the practitioner's passing and to inform them, especially in this specific instance where the files might be moved shortly, that they should collect their files as soon as possible, or that they may designate a new healthcare practitioner to whom the files could be transferred. Alternatively, they could inform the patients if they are unable to make arrangements at that time, then the executor will make further contact with them in due course. The basis for this advice would be that the practice secretary would already be divested with a right of access to the patient's contact information and to the patient files, as this would have been part of his or her duties during the day-to-day administration of the practice while the practitioner was still alive, as well as the fact that they would have system access and a working knowledge of where and how the files are stored. So this would obviously consequently allow for a more efficient process to take place. But essentially what we would like the practitioners listening in this evening to take away is to understand that your patient records do form part of your estate, and that in order to avoid any unnecessary administrative burdens on your loved ones or on whomever you've nominated as an executor, that this awareness should prompt that your records should be factored into your estate planning to circumvent any of these issues which may arise if you pass away and your patient records need to be dealt with and managed. So thank you very much. That's my topic, and I will move back on to my colleague Thandi, who will discuss the retention of patient records for retirement and if your practice is closed.
Thank you, Jessica, for that informative discussion. As discussed, I will briefly touch on what happens to the patient's records when a practitioner retires or closes their practice for other reasons. Now, the relevant ethical rules in this regard is to be found in Ethical Rule 10.5, 10.5.1 to 10.5.3 of Booklet 9, which provides for the safekeeping of patients' records. The ethical rules provide that if a healthcare practitioner in private practice decides to close their practice for whatever reason, they shall within 3 months of closure inform all their patients in writing that the practice is being closed as from a specific date. They shall also inform patients that requests may be made for their records to be transferred to another healthcare practitioner of their choice. Now, they must also inform patients that after the expiry of the 3 months period, the records will be kept in safekeeping for a period of at least 12 months by an identified healthcare practitioner or health institution with full authority to deal with the files as he or she may deem appropriate, provided the provisions of the rules on professional confidentiality are observed. It is important to note that patients must always be given an opportunity to access their records in these circumstances and if they wish to. Now, the regulations might be difficult to practically implement in a real-life situation, can be burdensome on the practitioner involved. So we have come up with some tips and advice to help with the implementation of the records in these specific circumstances. Practically, it may be difficult to effectively ensure that communication about the closure or sale of a practice reaches all patients timelessly as per the regulations. So it is advisable that practitioners must use their standard modes of communicating with their patients to distribute the communication in a more effective way. This may be over email, phone, or SMS, however way the practice usually communicates with the patients on their database. It is further recommended that they consider publishing a notice in the local newspapers, the practice website be updated with the information, and affix the notice to a notice board at the medical institution or facility where they practice. Practitioners must also bear in mind that they will require the patient's consent for the transfer of their records to another healthcare practitioner for patients who request to continue treatment or care elsewhere. Now, this is to avoid breaching patient confidentiality through non-authorized disclosure of the records, which in itself is contravention of the regulations and can have unpleasant consequences for the involved practitioner. To make things simple, we recommend that a general consent should be sent to all patients via the direct mode of communication for them to complete with their relevant details and return should they want to transfer their records to another practitioner. Now, patients in active treatment should specifically be catered for, and the referrals should be arranged for another practitioner to take over their care as soon as possible to ensure the continuity of care. Failure to cater for these specific patients can result in an HPCSA complaint on patient abandonment, which can be quite difficult to defend. Now, in cases of a sale of a practice, say a practitioner decides to sell their practice, the contract of sale must specifically cater for the custodianship of the records to ensure their retention and safety. Patients must also be informed of the arrangements as per the contract of sale to enable access to their records upon request. Now, compliance with EthiQal Rule 10.5.3 specifically is assumingly interpreted to mean that once the 12 months period has lapsed and the informed patients have not been to collect or made arrangements regarding their records, the custodian of the records has the authority to deal with the files appropriately in line with the rules of professional confidentiality, which may include destroying the files if they cannot continue to store them safely within their means. Now, the key takeaway points that we'll conclude with is to make practitioners aware that it is extremely important to know the specified timeframes for retaining records in practice in order for them to remain compliant with the regulations. When you are in private practice, your patient's records become part of your estate and should ideally be included in your estate planning to be administered by the appointed executor upon the practitioner's death. Patients must always be informed and allowed an opportunity to access their records upon death or retirement of a practitioner or when the practice is closed down for whatever reason. It is also important to remember to obtain consent from patients before the processing of their records for whatever purpose or the transfer of their records to another healthcare practitioner. And this is to guard against breaching patient confidentiality, which can again result in an HPCSA complaint. The failure to comply with the regulation can result in HPCSA complaints and at times civil action lodged against the involved practitioner, which can be quite stressful to deal with and have financial implications. It is also important to understand that because a practitioner is the trusted custodian of their patients' records, they carry the responsibility to ensure that such records are well retained, processed appropriately in line with the relevant regulations to promote patient confidentiality and transferred appropriately upon retirement or closure of a practice. Now, this responsibility is transferred to the practitioner's executor upon the death of a practitioner. Now, this brings us to the end of Jessica and I's discussion. I shall now hand over to Dr. Hlombe to introduce the next speaker. Thank you.
Thank you, Jessica and Tandy, for the informative presentation. It's an eye-opener for most of the practitioners, but I think the most important part from the presentation itself, I think there's two things. One, the booklet 9. If in doubt, you go to booklet 9, and that booklet 9 gives a lot of information. And also thank you for raising the matters around the shortcomings of that. I think this is where the advice and the direct advice are required. But we will take the questions. There are lots of questions around this. Those will be addressed at the end of the second presentation. The second presentation is by Mashuma Parker. She's also an ethical internal person, an admitted attorney, and a legal advisor. Mashuma.
Thank you so much, Dr. Hlombe. Good evening, everybody. As mentioned, my name is Mashuma Parker, and I'm one of the legal advisors that sits on the claims team at EthiQal. The topic that I will be discussing today is the treating of loved ones, the do's, the don'ts, what the implications thereof are, how to avoid the risks, and how to avoid the risks. By way of a quick look at the structure of this talk, I will first look at the question of whether there is a problem with the treating of loved ones. Thereafter, I will move on to consider the implications of treating a loved one, what the ethical guidance we have on the topic says, and then to note some tips on what to do and what not to do prior to concluding. So is there a problem with the treating of loved ones? I'm sure that most health practitioners listening in on this webinar will agree that request for medical advice and treatment is a very common experience amongst health practitioners, and that it can be for friends and family members of varying closeness to you. These requests can range from trivial, once-off, straightforward type of request, and they can extend to more complex requests for ongoing treatment. They can also extend further to requests for prescription of pharmaceuticals or for the issuing of sick certificates. So when trying to answer the question of whether it is problematic to treat loved ones, I thought that it was very useful for us to have a look at what the HPCSA's ethical guidelines says on the topic. In booklet 1 of the HPCSA's ethical guidelines, it says that being registered as a health professional confers a right and a privilege on you to practice the profession. As a result of this right and privilege conferred upon you, you have a corresponding moral and ethical duty to others and to society. Booklet 1 goes further to state what is considered to be a good health practitioner. And they say that a good health practitioner is a practitioner that will have a lifelong commitment to sound professional and ethical conduct, but also an overriding dedication to the interests and the well-being of your fellow human beings and society. So while most health practitioners are almost driven to respond to requests by family members because of a desire to do good or to alleviate some suffering, or because you want to minimize any harm suffered by that person, regardless of this dual relationship, you'd still need to ensure that you uphold the moral and ethical duties that you owe to these patients and to treat them in a manner that will be considered professionally sound and ethical. If there is any deviation from the standard, then yes, it can be said that your treatment of this family member or friend is considered problematic. And it is for exactly this reason that it is a useful exercise for health practitioners to proactively engage in this topic so that you can learn how to best protect yourself. So what are the implications that you would need to protect yourself from? I came across this passage written by Dr. James Hellenbeck, quoted in a very well-written article by Professor Eskling. Dr. Hellenbeck warns against the dangerous slippery slope that may result from the dual relationship that you have with family members or friends, in which special considerations made by health practitioners insidiously leads from small friendly acts of kindness to requests for favors that lie outside the bounds of propriety. He continues and he says, each step down the slope seems reasonable enough, but at a certain point, you realize you are in trouble, and climbing back to safety seems impossible. I thought that this captured the very precarious yet completely unintended risks that you could expose yourself to when treating family and friends in a very meaningful and persuasive way. If your conduct attracts regulatory attention, you could be subjected to the HPCSA complaints process, which is in and of itself an extremely stressful experience for health practitioners to go through. And you could be found guilty of unprofessional or unethical conduct. And one or a few of the following penalties can be imposed upon you in terms of the Health Professions Act. A caution or reprimand, or both. Suspension for a specific period of time from practice, removal of your name from the register, a fine, a compulsory period of community service, a payment of the cost of the proceedings, restitution, or both. In addition to this, if adverse outcomes materialize as a result of your conduct, it could attract possible civil litigation or criminal prosecution, or possibly both. Another implication is that it could result in reputational damage and possibly tarnish relationships with family and friends that you have had. So we'll now quickly move on to the ethical guidance on the topic. There's currently no law outrightly prohibiting medical practitioners from treating family members or friends. The HPCSA does not address the topic in its booklets directly, and there is no law that deals with the topic. However, the South African Medical Association quoted the following on its website, the gist of which deals with the treatment of immediate family members. It is stated that medical practitioners who wish to treat their own family members should note that the board resolution that was reached by the Medical and Dental Board in October 2007 deals with the treatment of immediate family members. It said that it was permissible for a practitioner to treat his or her immediate dependent, but that it was not permissible for a practitioner to render accounts for such services rendered to such dependents, except for laboratory fees and material used. Materials here is said to be interpreted as the dispensing of pharmaceuticals. So as a result of this, we see that there's no outright guidance in the law. And as a result of this, it would be necessary for us to have a look at the stances of other professional bodies and associations of other countries for a bit more guidance on the topic. So while it is not my intention to regurgitate what is stated on this slide, but to state the gist of it, being that similar to South Africa, there does not appear to be a clear laws prohibiting the treatment of loved ones and friends. But most ethical and legal guidelines of other countries advise doctors not to treat family members, friends, and people that they have close personal relationships with, except under exceptional circumstances such as an emergency, or if you really must for minor matters. If, however, you decide to treat a family member, the advice from the literature is that you should document whatever was done, and you should refrain from prescribing controlled substances. The reasons given for the stance is because of the possible lack of objectivity and discontinuity of care. So now we're at a point where we haven't moved much further from where we started. The ethical guidelines doesn't direct us into a direction. The SAMA says that's permissible when it comes to treating of family members, immediate family dependents, and the other professional bodies advise us to steer away from it. It's then useful for us to look at booklet 1 of the ethical guidelines. And booklet 1 states that the guidelines are there to guide and direct the practice of healthcare practitioners, but it also states that it is impossible to develop a complete set of specific ethical prescriptions that would be applicable to all conceivable real-life situations. It goes further on to state that healthcare practitioners may have to work out for yourselves what course of action could ethically be defended, and this requires a process of ethical reasoning. They've also listed a stepwise process in booklet 1 as to how you should engage in ethical reasoning, and it would be useful to doctors to refer to that section. Additionally, too, it's mentioned that amongst others, there are 13 core principles espoused in the guidelines that are the ethical values and standards that underlie the profession and ethical practice of the profession. And when you engage in this process of ethical reasoning, you need to be cognizant and aware of those. So we will now move on to consider the do's and the don'ts. But I thought a useful way to do this would perhaps be by a practical example. So this is a hypothetical scenario. You are a specialist gynecologist and you are close friends with the Peters family. At a social event, the Peters' adolescent daughter, Kelly, comes up to you and she discreetly inquires how she would know if she had acquired a sexually transmitted disease. You are caught completely off guard and in an immediately uncomfortable position. But Kelly signals you to please be discreet as the parents are in close vicinity. Kelly is also very good friends with your son, and you have never been sure about the status of their relationship. Feeling somewhat obliged to advise her, you move her to the corner of the room. You quickly inquire about her symptoms for the purposes of intending to write up a script for antibiotics. Let's work through this hypothetical scenario with the objective of trying to figure out how problematic it can be for you. From the heading of these slides, you will almost immediately be able to identify the lack of objectivity on your part because of the dual relationship that you hold with Kelly and her family. Although not apparent immediately, there also seems to be a conflict of interest between what would be in the best interest and well-being of Kelly and your own personal self-interest, particularly because of the uncertain effect that Kelly's health status could have on your son's status. However, you are under a duty to uphold doctor-patient confidentiality. So this is a dilemma that you'd need to grapple with. Then, if after this informal side room consultation, you felt pressurized into prescribing antibiotics to her without doing the necessary consultation and investigations, and without managing her expectations and setting clear boundaries in place by telling her what you had done, what you had not done, and what must still be done to call for a follow-up appointment, there would be a real risk that Kelly could complicate later. If she did in fact then complicate later and present to a hospital, there would be no record of this informal consultation, nor would Kelly remember what antibiotic you had prescribed to her. So there would be this clear discontinuity of care. You would also not have kept contemporaneous and proper record keeping, which means you would have not been compliant with your ethical guidelines. So regardless of your intention to minimize harm to Kelly by doing her a favor, you would have not only compromised her health, but you most certainly would have put yourself in a very precarious position. If we're thinking about taking this scenario a little further, we need to consider, was it truly an emergency that required immediate treatment? Or could you not instead have firstly managed Kelly's expectations to inform her that you could see her, but because of the dual relationship and possible problem of objectivity, that instead it could be useful for you to refer her to one of your trusted colleagues in either the public or the private sphere. It would then be good for you to encourage her to perhaps have the discussion with the parents, but if not, that is also not a problem. But then you'd sensitively then just put yourself in a position where you can facilitate that continuity of care. Anyway, let's say you decide to treat her yourself. Regardless of this conflict of interest, you see her in your office. Would Kelly really be forthcoming with the sensitive information that you require to make a proper diagnosis? Alternatively, would you be able to attain the necessary, yet maybe intimate and sensitive information in order for you to make a proper diagnosis? And if you were to go ahead and you attract regulatory attention, you would most certainly not objectively be able to confirm that your conduct was both professionally sound and ethical. And this is exactly where the problem comes in. Now, I would quickly like to look at some do's and don'ts on the topic, just as a quick guide for practitioners listening in. When receiving these type of requests, perhaps it's a good idea to assess each request on an individual basis and try to immediately understand what exactly the request is. Is it for once-off, straightforward, trivial type of advice, or is it for the more complex, ongoing type of treatment? Then be sure that you set clear expectations and put boundaries in place. So let's say, despite advising against treatment of people that you have this dual relationship with, that you decide that you would anyway want to go ahead and treat this person. And let's say that you have an informal corridor type of consultation. You need to clearly inform her what you did not do, what must still be done, as well as calling for necessary follow-ups and making sure that if there is a necessary referral that needs to be done, that is also put in place. You'd also need to make sure and look after this continuity of care because it's very important. In addition thereto, respect for patient confidentiality and patient autonomy must be guarded against, and you must make an effort to guard against paternalism. Also, decide whether you will be charging for services rendered and discuss this with the patient. While the board resolution of the HPCSA deals specifically with the treatment of immediate family members and advising against charging those immediate dependents of yours, it can still and should still be considered if it's not an immediate dependent and discussed with the patient before as a way of attaining informed financial consent. Lastly, guard against over-servicing of loved ones, avoid prescribing controlled substances, stay within your scope of practice, and place yourself generally in a comfortable position where you know that if at any point your conduct of a patient is questioned, that you are objectively able to illustrate that your conduct was both professionally sound and ethical using your patient records. So by way of conclusion, despite there being no law that outrightly prohibits the treating for medical practitioners to treat loved ones and family members, there's this quote that is very persuasive. It says, sometimes providing the best possible care will mean refusing to provide care at all, and instead directing them to someone who can. This is so particularly for family and friends where your objectivity may be diminished, which ultimately will not assist your patient. So I've listed on the next slide some 6 guidelines for you to remember if you do encounter this type of request. Perhaps as a start, think of the nature of the request. Is it for trivial once-off advice, or is it for ongoing, more complex type of treatment? What is your closeness with the patient? What is that varying level of closeness to you? Does it fall within your scope of practice? Identify all potential ethical challenges. Make sure that you are able to provide appropriate care and that you are comfortable in doing so. And then lastly, ensure that you are able to ethically justify all and any clinical decisions that you take. Thank you very much.
Thank you, Ms. Schumer. And back on. Thank you very much for the informative presentation. And I think this is one of those very difficult things for practitioners, because you really want to assist the family member. But I think one of the important things that Ms. Schumer has said is that really there is no legal guidance that is there. But, you know, as a professional, you always have to understand that even if you are treating a family member, there's the duty still lies with you that you maintain professionalism all the time. We are going to go into questions and answers at the moment. And the way that we thought we could run this part of the session is you still have to put in your questions under Q&A. And we'll start with those questions that were sent in during the registration time. And we will do the first presentation questions and answers, and then we will address the second presentation's questions and answers. So we'll have Thandi and Jessica addressing the first set of questions. We will start with those that were in the registration. I will start with, just to address those, maybe let me start with Tandy. Those that were in the registrations. The ones that are written on Q&A, we are going to address after we address the ones that we received earlier.
Thank you, Dr. Klembe. So I think to make things easier, I'll just address the first 4, and then Jessica can address the remaining other ones, maybe 4, and then I'll also come back and then we'll just interchange. The ones that we've touched on that were covered during the discussion, we will just make mention that it was covered, and if we can, we'll just go back to what we said about that specific question, just to make sure that the answer is clearer. So the first one that I have here, it reads, I'm interested to know how long patients' records should be kept. So this was covered and by Jessica specifically. So she did make mention that the ethical rules provide for a minimum of 6 years for the safekeeping of the records, and it's 21 years for minors, and the specific circumstances where you will be required to keep them for longer. So that is the short answer, minimum 6 years. The second one reads, how long should we keep files for, and are we still to send letters to GPs, knowing patients have more than one GP? So the answer to that is you can send referral letters to GPs upon the patient's request, or when a GP has specifically referred a patient to you, just to keep them updated in respect of their clinical condition. Oftentimes you will send letters of update if you are continuing with the patient's care, if there is clinical indications to do that. The third question reads, if we have historically kept patients' files, can we store them in a document warehouse, and for how long? Space is an issue in the office and we want to make sure that we are compliant. So the answer is, as long as the records are stored safely, it does not matter whether it's in storage. You must just make sure that you remain compliant with the minimum safekeeping regulations, so the minimum 6 years. And make sure that wherever the records are stored, there's no ease of access for unauthorized third parties to access the records, because you will be in contravention of the patient confidentiality. So that must always be maintained. The fourth one, which I'll stop at, reads, how long must patients' clinical and billing records be kept? And it's just a comment, looking forward to an interesting discussion. So this again was touched on in respect of the minimum years to actually keep records, and the specific different circumstances where you will be required to keep them longer. So if that's the case, then you just refer to booklet 9. I will hand over to Jessica to touch on the coming fourth, or the 4 ones that come after that. And then if there are more questions, I'll just come back again and then we'll interchange, depending on how much time we have left. Thank you.
Thanks, Tandy. So let me move on to the other questions that were received upon registration. So the question I have here says, am I obliged to destroy records after a number of years, or can I keep them indefinitely, as some patients return to one's practice unexpectedly? So the recommended record retention periods are all the minimum requirements. There aren't maximum requirements. So in short, yes, you can hang on to them for longer. The 6 years and the 21 years are just the minimum that you need to hang on to them, as well as the other statutory periods that we discussed earlier. The next question is with regard to IOD records. So that's injury on duty records. So as we mentioned during our presentation, that's treatment that falls under the purview of the Occupational Health and Safety Act. If you are treating WCC or COIDA patients, the Act requires you to keep those records for 20 years from the treatment date. So that's quite a much longer period than your standard 6 years. should surgical specimens be photographed and be included in the patient's notes? We would say, and obviously from our day-to-day experience with giving medical legal advice and dealing with clinical malpractice claims and HPCSA complaints, this would be considered the gold standard of and part of good, clear, detailed record keeping, and is good clinical practice to do so. So we would recommend doing that. We have a question here saying, how should families dispose of a deceased medical practitioner's medical records? So we touched on this topic just to make practitioners aware that their records will form part of the estate. So families should not dispose of a late practitioner's medical records until the process, as per the EthiQal guidelines, has been concluded. This being that either the practitioner who took over the late practitioner's practice has made the requisite contact with all the patients and notified them and given them the opportunity to come and collect their files or have their files transferred, or when the executor has fulfilled their duty and notified the patients of the practitioner's passing and afforded them the opportunity to collect the records or to request that they be transferred to a designated medical practitioner. Thereafter, the executor is required to keep the records or any records that haven't been collected yet for a minimum period of at least 12 months. We have a question here saying, with regard to the death of a patient, what is the process of disclosing medical information to the family? So the next of kin of a deceased patient is entitled to request copies of that patient's medical records. They must comply with the provisions of the Promotion of Access to Information Act, and they need to complete the necessary form and provide proof of their relationship to the deceased patient. So that would be the marriage certificate or a birth certificate if it's the children of the deceased patient, just some form of proof that they are a next of kin of the deceased patient in order to make that request compliant, and then you can provide them with copies of the late patient's records. We also received, and I found this personally an interesting question: how long should I keep a record of a deceased patient? So the death of a patient doesn't change the retention period per se. So it remains the recommended minimum period of 6 years from the last date of treatment or last interaction with the patient or entry into the clinical records. However, if the death is certified as unnatural, either by a doctor or by SAPS or the state, then it would be prudent to keep those records indefinitely until the inquest process is over. And the reason for this being that you don't want to land yourself in a position as a practitioner of being accused of obstructing justice by destroying evidence. So when dealing with an unnatural death that is likely the subject of an inquest or SAPS investigation, it's much safer to retain those records indefinitely, even if the patient is deceased. And I think that's I don't know if there's any other questions here that we received that I can hand over to Tandy to move on and answer.
Right, thank you for those questions. Those are the questions that we received during registration. And I think they're very important questions. And thanks to Tandy and Jess for addressing those questions. Now we'd move on to the current questions that are really that we can all see. Maybe let's start with the first one, Jess. I think that one is we'll just break the rule a little bit there and say the legal age for consenting.
Sure. So that answer is just with reference to our topic of the retention of patient records. When we say minor and that those records need to be kept for 21 years, yes, in South African law, a minor is considered to be up until the age of 18, and the record retention periods are separate to the age of consent to medical treatment. So we are talking about keeping records up until the age of 21 years when treating a child.
Thank you for that. Just the question or the comment basically from the one that says first world guidelines or law is not always to be practical, such as patients should always have their records, histology at all times. I think that is it's an important aspect. However, it's important to know that the originals should always be with the practitioner, because we have had cases previously where the practitioner has given the records, specifically radiology reports and pathology reports, to the patient. And the patient 2 years later comes back and there's an action against, and we don't have those reports. So if you decide to give the patient the file or the records, ensure that that is done in a way that your originals are kept with you. But the advice that we always give, and the advice that from an HPCSA point, is a summary of treatment, discharge summary, just a report, because to give them your full records sometimes is a bit problematic, because they will tend to interpret and they go to Dr. and Prof. Google, and then they have real problems and they just raise issues that are really not necessary from a clinical or a medical point. So on that point, I think we're just going to give advice that maybe just a summary of what has happened is what is expected. And the next question, if we give patients their records, should there be a form that they sign? Jess?
Thank you very much for this question, Dr. Hasim. Yes, we as attorneys and legal advisors love a good paper trail. There's nothing better. That's the best way to cover yourself and for us to keep track of things that have transpired, and especially record keeping. So I think it is a good idea to have, it doesn't need to be anything complicated, a very standard form. If a patient does come and collect their own original hard copy folder because they're moving to a different province or different country, or for whatever reason, just a standard form that they sign and acknowledge, that details there that they know that they've acknowledged that you've handed them their entire complete patient file and that is now in their possession. And then I would recommend just filing that form in your system, whether it's a filing cabinet or electronically, where you would have had the hard copy patient file. And then your question goes on to ask who keeps those forms if the practitioner passes away. So if those forms are stored with your patient records, then that would just fall to the same duties that the executor needs to fulfill, or that the new healthcare practitioner that's taken over the practice would just keep that form in place of the patient records for that 12-month period, to just ensure that that can be verified if the patient were to potentially come back and deny that they had collected the file or anything like that.
And I would guess the same rules apply even if it's electronic records. You just keep the records safe and you follow the rules as prescribed. You know, by the same process. Tandy, if a practitioner tends to sell or close the practice, how long in advance should he or she advise patients of their intentions?
Thanks, Dr. Klambe. The rules state that it must preferably be 3 months before closure, but just because, practically implementing that might be difficult, especially if you've got a big database when it comes to patients. So anytime, before the 3 months period, it could even be a year before. I'm sure retirement is something that you do plan. So if you do it much earlier, then the better you'll be able to reach all your patients. But the minimum prescribed period is 3 months before the closure, before the closing specific date.
Just on that question, Because I mean, this happens all the time. I mean, you guys from the legal side, we all know that there are instances where even current patients, you contact them, you want to give them the results, or you can't get hold of them. So what is important here? Is it proof that you've tried to contact them, or is it you want to ensure that there was a response?
Thanks, Dr. Hlembe. And I think, again, it goes to, the practical implementation of the regulations. So like Jessica said, as attorneys, paper trail is all you need. So proof of communication from your side will suffice. So where there's an email, showing that you send an email at a specific time to this patient, make sure that their email address is correct, and that should suffice.
SMS, WhatsApp?
Most of communication. Yes.
As long as you keep them.
Yes. So WhatsApp, phone, SMS, I always say, whatever mode of communication that the practitioner normally uses and is more comfortable with when reaching their patients, that will suffice, as long as there will be trail of that communication from the practice to the patient.
Okay. Jess, anesthetic records? I mean, anesthetists, they see, this patient once and probably they'll never see them. And the rules still apply?
Yes, the rules still do apply because they are registered practitioners and they do need to follow the HPCSA EthiQal guidelines on patient record keeping. It can often cause quite a headache if you are dealing with a case and the anesthetic records were potentially only available in the hospital file, and they grow legs and they walk away and you can't find them and you're trying to investigate. So we do obviously highly recommend that those records do be kept by the anaesthetists themselves, but also in practice, what we can suggest is that a copy of the anaesthetist's records always be provided to the primary treating medical practitioner that is managing that patient. So even in a multidisciplinary team, if you've got a patient with multiple doctors, like a physician and a specialist, as long as the main primary doctor has a copy of the anesthetic records, and then there should be also a copy in the hospital file. But the best case scenario and the gold standard again would be for the anaesthetists themselves to retain those records, even if they only did see the patient once, and they would be subject to the same retention periods as other practitioners.
Just on that, there is another anesthetic related question. If you can find it. This one says, what is the case of anesthesia practice and record keeping? I think you've done that. We don't have practice as such with repeat patients and most on-the-sea patients. What do we do with a practitioner deceased estate then and the patient records of their whole professional career? One can't contact 15,000 or 20,000 patients. So does it also apply? Just like, the same application. Is there no difference in terms of what is required of anesthetists?
Yes, that is obviously an issue that we face, and what we were trying to convey with the EthiQal guidelines is that it's all well and good to stipulate that there, but in practice, like you say, you've got 15,000 patient records going back however many years, and it can be very burdensome on a family member or an estate, which is why it is a good idea to make it part of your estate planning, because then you can come up with your own solutions and dictate that to your estate planning attorney and make that part of your plan, so that those can be dealt with in a manner that's not so burdensome on whomever is managing your estate if you pass away. But the EthiQal rules do still apply.
All right, thank you. In the interest of time, there are several questions related to POPI Act. Tandy, I mean, do guidelines supersede, HPCSA guidelines supersede POPI? And I think there is another question just at the bottom that talks about POPI.
Yes,
For
thanks,
instance,
Dr.
this year, does POPI Act state we have to get rid of records after 6 years?
Thank you
Just
so
in
much.
general.
Dr. Yes, I did see there's quite a lot of question on POPI and just how it engages with the HPCSA regulation. So I think just to start, it's important to note that the POPI Act does not replace the HPCSA regulations. The HPCSA regulations are specifically drafted to manage the relationship between doctor and patient. So they're more applicable to practitioners, to medical healthcare practitioners than the POPI Act, although it does, come to play as well. It's also important to note that the POPI Act is in respect of all private and public organizations or institutions, whereas the HPCSA regulation still deals specifically with doctors and patients. So in answering your question, I wouldn't necessarily say it supersedes POPI Act, and this is because when you comply with the HPCSA regulation, there is an automatic compliance with POPI Act. So for example, POPI Act will not be as clear as to how long to keep medical records per se, because they just refer to confidential information. But you know that they will say in the act that the confidential information must be retained for as long as they're necessary to serve a certain legitimate purpose. Whereas the HPCSA will give you the straightforward answer to say minimum 6 years for retaining the record. So as medical practitioner, advice is first go to the HPCSA guidelines, because 90% of the time complying with the HPCSA guidelines, you automatically comply with POPI. I hope that answers the question. Thanks, Dr. Klembe.
All right. Thank you. I think, yeah, it gives us a good idea. I think there's a question here that says, why do we need to keep COID or the occupational related records for a minimum of 20 years? Maybe I can take that. The one big reason for that is, let's take, for instance, people who've been working in different mines, because this is an example that I know well, where the development of diseases, that occupational diseases, some of them, they manifest many years after you've left the employment. Imagine now the cases that, currently there are cases that are dealing with asbestosis, silicosis, and others. So within 6 years, if you destroy those records, probably that patient is not known where the patient comes from, whether that patient worked at the mines. It's only at a later stage when it's the diagnosis is actually made that actually this respiratory condition is related to the occupation where this person was working. It is difficult from a legal point or from an act that will just delineate and says, if you're working a factory like this, if you're working in a garden, or if you're working like that, keep these records. It's better to have a blanket rule that says 20 years. So it's about the manifestation of occupational acquired conditions. I'm not sure if I've taken that question well, Jess, Tandy, Mashuma. I just need one to say, yes, it's fine.
Yes, Dr. Klembe, that was quite elaborate.
Okay. I'm just looking for the other question, and in the interest of time, because we just want to be done by at least 7:30. I think there are some questions here that are important in terms of direct questions. If you need to be addressed those questions directly, you can always contact us. There is a question around the recording, whether it will be made available. I think, again, those that really want the presentation, you can contact us directly, then we will make arrangements. But at the moment, we are not going to make it available publicly unless, we decide that will happen. So those practitioners that really want to have it, please contact us. Maybe let's talk to some questions from the treating family members. Mashuma, there are those questions that we also received from the registration period. Can you please just a few of those to address them? Thank you.
Thank you very much, Dr. Shlombe. So the first question that came through is, what would you advise surgeons who say that they do not have a problem with operating on their own family members? So this was answered in the talk. And as it stands, in South Africa, there is no law outrightly prohibiting the treatment of family members or friends. However, we must just also note what the broad resolution of the HPCSA said, that it was permissible to treat immediate family dependents, but that it was not permissible to charge them for services rendered, except for things like dispensing of pharmaceuticals and lab tests. So despite this permissibility, the professional bodies of other countries advise steering away from treating loved ones and family members because of the clear lack of objectivity and possibility of discontinuity of care. To however directly answer the question, I think maybe it would be important to rely on the principles or lessons learned in my talk, which says that as a start, what you need to ask yourself is this a straightforward advice, or is it something for more complex ongoing treatment? And I think something like a surgery definitely is something more major and more serious. So by way of answering the question, I think that because it's not outrightly prohibited, it really is within the practitioner's discretion. You'd, however, need to ensure that all your ethical duties are upheld, particularly the duty of patient autonomy, amongst others, and to put yourself in a position that if you were to be questioned or your decisions were to be challenged later on, that you'd be able to ethically justify them with supporting documentation. Okay, and then the next question relates to the treating of employees, whether it's ethical or not. So when researching this topic, I actually came across this quite a lot in other countries. And it said that actually the treating of employees is actually included when discussing this particular topic. And so the same applies really. You might have some sort of close personal relationship with this employee, regardless of the varying levels of closeness with them. There is still this dual relationship. And therefore, it brings me perhaps back to that quote by Dr. James Hillenbeck, that perhaps it starts out with friendly acts of kindness, but at some point you're so far down the line with these acts of kindness. And although each one of those acts can be reasonable enough and justifiable, you might end up in a very precarious position that you're so far in that it's difficult to actually get out of the situation. However, there is no outright law prohibiting it. So similar to the first question, you'll just need to ensure that you are able to ethically justify professionally sound and ethical conduct. Then the next question is, what is acceptable emergency treatment on a loved one? When it comes to this particular issue, emergency treatment is emergency treatment. The objective here would be for you to stabilize the patient. If at that point, once you've stabilized the patient and the patient's health is no longer in danger, it's not a life and a death situation, then it would be okay for you to perhaps attain the services maybe of an ambulance for purposes of transferring the patient to the nearest hospital for further treatment. Then there's a question about, what if you realize that a family member is unwittingly being treated unethically or being exploited by a medical colleague? Should you get involved? There's a similar question that states, what are the steps to take if a medical professional, you can see that the treatment given to your family and friends is not appropriate? So although there's not a general answer to this question, booklet 1 actually addresses the duties of reporting misconduct. So the rule is Rule 10, reporting misconduct, and it says that you are obligated, a health practitioner must report violations and seek redress where they have good or persuasive reason to believe that the right of patients are being violated, or where the conduct of the practitioner is unethical. The emphasis here is that you must ensure that you have persuasive reason to believe or that there is some untoward conduct here. And then it goes further, and I think this is important to mention, that where it is in a practitioner's power, you need to protect people who report misconduct from victimization and intimidation. The next question relates to what are ethical boundaries regarding treating friends and colleagues, treating friends of colleagues. So the answer to this question is actually really simple. If there's no close personal relationship here, then there is the concern of a lack of objectivity is no longer there. So you would afford this patient the same professional expertise that you would any other patient and treat the patient accordingly, upholding all the necessary ethical and professional duties that's imposed on you. And also additionally to ensure that you uphold your duty of patient confidentiality, and that should never be a topic of discussion with your colleague friend. Then there is a question about, am I allowed to bill medical scheme when treating loved ones? So here, we need to quickly look at the HPCSA's board resolution of 2007 that specifically dealt with the treatment of immediate family members. It is permissible, they say, to treat immediate family dependents, but it is not permissible to render accounts to them except for medication and lab tests. It's however not clear from this resolution whether it doesn't extend to non-dependent family or family further down the line or to friends. And in other countries, the literature actually proposes that if you're going to treat these people that have this close relationship with you, that it might strengthen the argument for you to charge them and strengthen the argument that there is this normal legal patient doctor-patient relationship with the patient. So as mentioned in the talk, it's definitely something that should be considered when you decide to treat the patient, if you decide to treat the patient. And from a financial informed consent perspective, it's important to attain that person's financial informed consent in order to avoid, obviously, the HPCSA complaints process. Thank you very much, Dr. Shlombe.
Thank you for that, Ms. Schumer. I think also the important part in all of these questions, especially treating family or close colleagues or employees, it's important to always realize that your professional, the ethical conduct is important. The professional guidelines you need to follow. But I mean, it's an important thing to also understand that if, for instance, there is a patient or there is a family member that comes to you just asking for, I've got this sore throat, you look at and you think just an antibiotic is required. All the health practitioners that are here, they probably have had a situation where just give me a prescription for this. It's something that is practical. It's something that is done to all of us. But the onus lies on you as the practitioner who is requested. You have the knowledge. You need to look at the situation yourself and determine if I start giving this patient or this friend or this brother of mine a prescription without doing the proper examination and investigation, what are the implications? But the person in front of you would really be determine whether you can take that chance or not. So the responsibility goes back to you to determine if, no, this is serious enough. I mean, I get this request all the time, especially as a person from the rural areas. I get this request all the time, asked to give opinion, asked to, share tablets. Please, when you come back, please, you must give us Ipilisi Zamatam. You always get that, but at the end, the onus is on you as a professional to determine if that is appropriate or not, especially in the environment where there are no clear guidelines or no clear rules. I think there's an interesting question that says, now, what happens if a close relative or a friend comes for a second opinion? She's not asking to treat, been treated by another doctor somewhere, but it says, look, you're a doctor, have a look. You know, what are the implications, Ms. Schumer, or anyone?
Thank you, Dr. Shlombe. So the implications remain the same, whether it's a first opinion or a second opinion. I mean, if I suppose the patient has been assessed by another practitioner and it's your discretion as to whether you feel comfortable with providing her with that care and treatment, then perhaps you'll need to ensure that you still follow all your ethical duties and obligations. So for example, if there is specific examinations and investigations that needs to be done, you do that. You thoroughly assess her, bring her into the formal sphere. Let it not be these informal corridor type of consultations, because that is specifically where it becomes problematic. But if you can perhaps afford this patient the same professional expertise that you would any other patient, and you be able to ethically justify it, then there is no law outrightly prohibiting this. And it's a call for that doctor to make, knowing that the implications actually stay the same.
I tell you the way it usually gets presented. You know, this is a mother-in-law that has gone to hospital, comes back, has taken some medication, comes to you and says, do you think this medication is right for my condition? Right? So those are the types of questions that you get asked as a person in the family who really has the clinical or the medical knowledge. You know, so those kinds of second opinions are not always, you know, as intense as formal second opinions. So what the advice really, again, as Ms. Schumer has said, is that you could just give an opinion that is not a second opinion, where you would say, rather, you go and consult professionally another practitioner in the same field as the one that you want a second opinion from, because I think I am not as qualified from a closeness and a relationship point of view to be as objective when I give you the second opinion. So that becomes important. The other one that is important there, I mean, just as an advice to all of us as practitioners, please let's not try and say, this is nonsense. What was he thinking when he did or she did this? Because patients, they take those. And we receive claims, we receive complaints, doctors receive, you know, written complaints from patients saying another doctor who has not examined me, just looked at what happens. He says, this doctor should not have done this. I would have done it differently. Then we receive complaints from patients that we need to deal with. If you do that, you must think about it this way. Another practitioner can do that to you too. Rather say, look, I'm not going to give you an opinion like that unless I have done a thorough examination and investigation, and then I'm able to give an opinion. But that second opinion should really try not to talk bad about the doctor that treated first, because the circumstance might have been different. So that's a plea from our side to ensure that don't give the second opinions in that way. The other one that is important, maybe it cuts across the confidentiality. What happens when this patient dies? Maybe at a condition that says, I don't want my family to know. The commonest one is HIV. I mean, where Jessica Tandy was talking about the records. So it is important, therefore, to just let's give what happens there.
Thanks, Lompe. This is a tricky one, actually, and an interesting question that has already sparked a discussion between myself and Thandi over WhatsApp. What is the correct answer here? So the caveat is that we don't always have all the answers. And it is a debate to have because, you know, that patient obviously had wishes during their lifetime and their patient confidentiality was paramount to respect those wishes. But the rules, regulations, POPI and the Promotion of Access to Information Act do allow for family members to make requests for patient records after they've passed away. And the other question is, I suppose, one would query, well, what is the reason behind the request when those family members are coming to the practitioner to ask for their loved ones' records? Are they trying to find out the cause of death? What is the reason behind that request? And also, you know, did the patient pass away as a result of the virus, or is that just something that is kind of an incidental annotation in the notes, but not relevant to the reason that they're being requested? So those are kind of the questions that are churning at the moment, and I don't have a clear answer. I would say that if the family members comply, the patient has passed away and they have the right to ask for those records, then they should be entitled to them. But I stand to be corrected and persuaded otherwise.
I'm just thinking that that is correct, Jessica. But the other part is, if you read the confidentiality section of booklet 2 of the HPCSA, it clearly states that that confidentiality remains even after death, right? However, I would think that the express instruction from the patient, please, I don't want these people to know that I'm HIV positive. You'd probably be able to take the record that says the patient was HIV positive and not disclose it, because that confidentiality remains until death. I would assume that, but as you said, we don't always have the correct answers. We don't always have the answers. I think, especially in a forum like this one, but if that question is really a burning question, you can contact us directly. Then we have time to consult other people. We have time to actually read further onto it. So the answer that you are giving here, as we said, it's not a legal opinion at all. Don't use it and say this is what we said. But if you ask it directly, then we'll be able to assist, because we would have time to think, we'll have time to research, we'll have time to ask other experts. We've now come to 1930, which is the time that we're supposed to stop. And I wish we could just continue. However, I really think that this has been a very interesting discussion. And thank you for all the questions. Some of them have been addressed. Others, there are those that we have not really addressed. If your question is really burning, there are two things that you want to do. Booklet 9, booklet 2, booklet 1 from the HPCSA. Booklet 2 is one of the most important booklets. So please, some of these questions can be addressed there. But if it's really burning and it's direct for you, you are welcome to contact us. I've been saying contact us without giving you contact details. Send an email to info@ethiqal.co.za. That is where you just send the request or any questions that you'd have. Once it reaches info, it will be directed to the correct person or to the correct people that could address some of the questions. That includes the request for the recording of this. So if you do that. We're coming now to close. There's a survey at the end of this. Please ensure that you complete the survey. I've seen a lot of questions and responses here that say very informative. We really would want to do such informative webinars directed at your needs. At the end, I would like to thank our presenters, Thandi, Mashuma, Jess. Thank you very much. It's been informative even to me as a non-legal person. I was asked not to say anything about lawyers, but I must say that this group of lawyers are our lawyers. There are lawyers that are very close to doctors. There are lawyers that are really good at what they do. They've got the doctors in their hearts. I know that doctors and lawyers are like dogs and cats, but these ones are on the side of the doctor. So if you see or you talk or you receive a call from them, know that they are on your side. So without wasting more than another 2 minutes, thank you very much. The survey, please, it will help us. Thank you.